Program Insights. Now we bring you a discussion on various provisions against organized crime under Bhartiya Nyaya Sanhita. The participants are Atul Kumar Mathur, former Director General of Police, and Piyush Pandey, journalist.
In a landmark move to reform the criminal justice system, three newly acted laws, the Bhartiya Nyaya Sanhita, the Bhartiya Nagrik Suraksha Sanhita, and the Bhartiya Sakshi Adhiniyam, will come into effect from 1st July. These laws, introduced in Parliament during its monsoon session in August last year, will replace the colonial era Indian Penal Code and the Code of Criminal Procedure and the Indian Evidence Act of 1872. What will be the effect of the implementation of the Bhartiya Nyaya Sanhita, which refers to justice instead of punishment, and what new provisions have been added to it, including snatching and mob lynching. Today we have former DGP Atul Kumar Mathur as an expert to discuss this. Welcome, sir. And sir, my first question is Bhartiya Nyaya Sanhita will replace the 163-year-old IPC, bringing significant changes to penal law. A notable introduction is community service as a form of punishment under Section 4. However, the exact nature of community service to be performed remain unspecified. What is your opinion?
Thank you very much and good afternoon to all my listeners. We are discussing about the new laws which are going to be enforced from the 1st of July. I must congratulate the nation that at last we have got our own laws, our own parliament passed laws which are going to be implemented from the 1st. So long we have been under the laws of British Parliament, that is IPC, CRPC and Evidence Act, and all the three will now be enforced. They are being replaced and we will be having a new laws. First of all, I must say that the namesake, it was Indian Penal Code or Bhartiya Dand Sanhita. There were two versions of the name of a book which was dealing with the substantive criminal law. Now there will be only one version, that is Hindi version, that is Bhartiya Nyaya Sanhita. And it has no English version of it. And change between two is what Nyaya has been added in place of Dand. The focal point is shifted. It has become victim-centric. When we speak about the Dand, we think about the penalty. What comes to our imagination is the person who is guilty of some offense and he has to be punished. So we have to decide his guilt and the punishment he deserves. There was no victim in our imagination with this word. Now the Nyaya word has been replaced. It gives us a mandate. It gives us a direction that not only think about the guilty and the punishment to be given to him, you must think and you must keep victim in view, and victim-centric laws have been made. We have to think that Nyaya is for both. It is for victim as well as for the accused person and convicted person. So these laws have been reformed, they have been reset. Most of the bulk of the provisions have been retained, but the new provisions which were required by the conditions of this country and the developments and technological developments and other factors which previous laws have been very inadequate, and adequate provisions have been made in the new BNS and other acts.
Sir, my second question is basically sexual offences see tough measures with a law prescribing up to 10 years of imprisonment and fines for those who engage in deceitful sexual intercourse by promising marriage without the intent of fulfill it. The new law also address deceit promises related to employment, promotion or marriage by concealing one's identity. Women will get better protection from this. What do you say?
It is a very welcome change because you see, over a period, initially IPC was not properly equipped to deal with the offences against women and children in the way we wanted to have it, because the society was changing and mal-discipline of people on streets and other places was seen, and criminal activity against women and children was gradually increasing. We had suffered many major incidents where Supreme Court had to issue guidelines, safety at workplaces, safety at roads, and deterrent punishment for the rapes and gang rapes especially. So as the cases were occurring, the amendments were brought in and they were incorporated in IPC because sequence of section numbers was fixed from 1 to 511. So they have been added as a ABC of the sections wherever we could find. Now this
Yes.
new law has made a separate chapter and they have been brought together in the chapter. And that chapter is offences against women and child. All the relevant provisions and new provisions have been added. And some provisions which were not there, like you have referred to sexual intercourse by employing deceitful means under section 69 has been added.
As you know, many important sections have been included in it. In view of the current circumstances, such as organized crime now faces comprehensive legal scrutiny covering a broad spectrum of illegal activities. These activities, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offences, cyber crimes, and trafficking in persons, drug weapons, or illicit goods or services. How do you see these streams? How effective will this be in curbing the increasing crime in the society?
You see, over a period of time, organized crime have been on rise, and we were not having adequate provisions, deterrent provisions in IPC. We were to take shelter of the standard criminal provisions about crime and try to manage the cases to come up. Some states have come up with the special laws of organized crime. They are still in existence. But there was no appropriate comprehensive definition of these crimes or organized crimes in our domestic law, general criminal law. Whenever a case occurs and if it is covered under a special law, the rule is that special law will prevail, general law will not prevail. But many times, because of technical difficulties, people escape liability under the special law and then there is no adequate backup law to cover them up. So this new definition helped to administration, law enforcement to cover them under some provisions of the general law and adequately deal with them, and the deterrent will be created and remedies will be found in the normal course.
So my next question is, for other important sections have been added which struggle with human trafficking for prostitution or ransom conducted by individuals or groups acting in concert as member of organized crime syndicates or on behalf of such syndicates will face severe penalties. These crimes executed through violence, threats, and other unlawful means for direct or indirect material gain will be met with tough punishment. What is your opinion, sir?
Yes, the severity of the punishment is proportionate to the grit. The offense is very serious, and section 143 of the new BNS, Bhartiya Nyaya Sanhita, deals with trafficking of person. Here I may tell you that this time the attempts have been made to make it gender neutral for the purpose of victim. Victim can be men as well as women, and it says whoever for the purpose of exploitation recruits, transports, harbors, transfers or receives a person by threats, by force, by abduction, by practicing fraud, by abuse of power, by inducement, etc., he is committing the offense of trafficking. And then there are situations where the trafficking has been taken care of. In a different situation, the punishment degree is changed from normal to severe.
Sir, my next question related to national security. For the acts threatening national security, the BNS defines a terrorist act as any activity that threatens the unity, integrity, sovereignty, or economic security of India with the intent to strike terror among people. What would you say to the authorities before implementing this?
Terrorism has been a big threat to the nation from some time. Ever since we gained independence, we are facing this problem from our neighborhood and from other places, and it is causing a very big hurdle for our progress and peaceful living. So India has been very vocal in international forums about the international terrorism and imported terrorism. We have been claiming and we have been demanding at an international forum like UNO and other platforms that there should be a comprehensive definition of terrorism. But how it could not be managed so far. The world community has not agreed to one common definition of terrorism. But it is appropriate and it was due on the part of India that at least in our domestic laws, there should be an appropriate definition of terrorist act. An attempt has been made under section 113 of the BNS to give it a shape of reality, and certain activities have been incorporated, have been listed, which will amount to be terrorist act, and whoever does any act with the intent to threaten or likely to threaten the unity, integrity and sovereignty, security or economic security of India, and then there are large number of activities which are listed.
So now we got a definition of terrorist act. Sir, the legislation also addressed the grave issue of mob lynching. It states when a group of five or more persons acting in concert commits murder on the ground of race, caste, or community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment of life and shall also be liable to fine. What would you say?
Yes.
Is there a need to be careful in such matters? What is your opinion?
It is a very important question and very important topic because for some time there have been a big demand that mob lynching has not been adequately covered under Indian laws and the punishment for murder was the only remedy which we were imposing. Now you see in a criminal law there are two type of liabilities. One is individual liability, one is joint liability. So murder in a per se in isolation with any other thing can be an individual liability. And if you have to make it a joint liability, then sections like 34 of the IPC and 149 of the IPC common liability sections were to be invoked. And there were difficulty in getting them proved in the court. Now mob lynching has been recognized as an offense per se. It is
Yes.
not linked with
Yes.
murder. So what if they have done? Section 302 has now been converted into section 103 and the part 2
Yes.
of 103 punishment for murder has been given to this punishment for mob lynching. Though word mob lynching has not been specifically used in this section, but as you read that when a group of five or more persons, you see group of five or more persons can constitute unlawful assembly as well. But the
Yes.
legislature draftman has careful about that they have not used the word unlawful assembly because it has further legal
Yes.
implications. So they say if a group of five or more persons indulge in. Now you see the grounds have been given. For the murder,
Yes.
usually no ground is required if the result is murder. But here they
Yes.
say that if they commit a murder for purpose, for the grounds have been specific and the grounds are very specific that race, caste or community, sex, place of birth, language, personal belief or any other similar ground. You see, this is a very important thing that it is not an exhaustive list of the grounds. They have given a scope that if there is any other ground. Now, when we say any
Yes.
other similar ground, then law of interpretation has to be used and a maximum justum generis has to be used to find
Yes.
what type of ground can be added here. And police has to be, or law enforcement has to see three things. First of all, that there should be five or more persons. Second thing, there should
Yes.
be murder. And when we say murder, then murder cannot be rational negligent. Murder is intentional or with knowledge. Because the moment we take the word murder into account, we have to go to the definition of murder, which is based on intention, intentional killing, or killing with knowledge. So one of the factors should be there, or both factors should be there. And
Yes.
then the grounds should be specific. Now, once this is established, then we can have a joint liability. Every member of that group will be equally liable for the murder as if he alone has committed the murder, and then punishment for imprisonment of life and fine has been imposed.
Yes.
And if it is not murder, if he has only given a grievous hurt, they have left him alive with a dangerous injuries, then there another section covers that thing, and mob lynching
Yes.
or mob voluntary causing grievous hurt covers that thing. I only request my listeners that this law is meant for us. This is now people-centric. This is victim-centric. And all the enforcement officers, while they function in the field, should keep in mind that victim is a very important stakeholder in the criminal act. And we should give due regard to the victim and bring the justice near to the people. And we should satisfy the needs of justice with due care and diligence.
Sure, we will see the effects in future implementation of Bhartiya Nyaya Sanhita. Today, we heard DGP Atul Kumar Mathur as an expert in the discussion. Thank you so much, sir.
Thank you very much.
You were listening to a discussion on various provisions against organized crime under Bhartiya Nyaya Sanhita. The participants were Atul Kumar Mathur, former Director General of Police, and Piyush Pandey, journalist. This program was produced and presented by the News Services Division of Akashvani. You can listen to it on our mobile app News on AIR. This program is also available on our YouTube channel News on AIR Official. You may share your feedback about this program through email at airnsdtalks@gmail.com